The first thing I heard was the unmistakable sound of metal grinding against steel. I dropped the polishing cloth from my hand and sprinted toward the front of my garage, my heart hammering against my ribs. "No! Stop!" I shouted. A massive flatbed tow truck sat halfway across my driveway. Thick winch cables were already hooked around the front suspension of my 1958 Rolls-Royce Silver Cloud. The same car I'd spent nearly 3 years bringing back from what most people called an impossible wreck. The chrome grille glistened under the afternoon sun, but now it trembled as the cable tightened. Standing beside the truck was my next-door neighbor, Karen Whitmore. She wasn't smiling. She was smirking, the kind of smile someone wears when they're absolutely convinced they've already won. She folded her arms across her designer blazer and spoke loudly enough for every neighbor gathering on the sidewalks to hear. "That's HOA property now," she announced. "You abandoned it for years. According to community regulations, we've taken possession." I stared at her, unable to process what she'd just said. "Are you out of your mind?" I asked. "I restored that car." She shrugged as if I'd commented on the weather. "You restored it on HOA-controlled property, my own driveway, our community's aesthetic jurisdiction." The tow operator glanced between us. "Ma'am," he said cautiously, "before I move this vehicle, I need confirmation there's no ownership dispute." Karen pulled a thick folder from beneath her arm. "There isn't," she replied confidently. "The HOA president signed the authorization this morning." She handed him several papers. He skimmed them, then looked at me. "I'm sorry, sir." I reached into my pocket so fast I nearly dropped my wallet. "The title," I said, pulling out the folded registration I'd carried since finishing the restoration. "Here's the title. Here's the registration. It's insured. It's licensed. It's mine." The driver frowned. Karen rolled her eyes dramatically. "Fake copies. They're issued by the state. I've already spoken to the HOA attorney." A crowd had formed by then. People whispered. Some recorded everything with their phones. Others simply watched, unsure who to believe. An elderly man from across the street slowly shook his head. "I've watched him rebuild that Rolls every weekend for almost 3 years, he muttered. Karen snapped toward him. "Nobody asked you." Then she turned back toward me. "You had every opportunity to comply with HOA rules. I never received a single violation notice because you ignored them." "I ignored letters that never existed?" She stepped closer until only a few feet separated us. Her voice dropped low enough that only I could hear. "You embarrassed me at the last board meeting." I blinked. "This wasn't about the car. It never had been. You challenged my authority," she whispered. "So now I'm reminding the neighborhood exactly who runs this community." The tow truck's hydraulic winch groaned. The Silver Cloud lurched forward several inches. Every instinct in my body screamed to jump in front of it. Instead, I planted myself directly between the truck and the Rolls-Royce. "If you move one more inch," I said, "you're stealing a vehicle worth over $300,000. Karen laughed. "No!" She pointed directly at me. "You stole it from this neighborhood." Before I could answer, 2 county sheriff's deputies pulled into the cul-de-sac with their emergency lights flashing. The entire street fell silent. One deputy stepped out holding a clipboard. He looked first at me, then at Karen, then at the Rolls-Royce. Finally, he said something that made every single person on the street freeze. "Which one of you," he asked, "filed the report claiming this vehicle belongs to the Whitmore Estate Trust?" The deputy's question hung in the air like thunder that refused to break. Karen didn't hesitate. "I did," she answered, raising her hand with complete confidence. "I'm Karen Whitmore, president of the Willow Creek Estates Homeowners Association. That vehicle belongs to property held under the Whitmore Estate Trust." I stared at her. "The Whitmore Estate Trust?" I repeated. "I've never even heard of it." She gave me a pitying smile, the kind people use when they think they've already outsmarted you. "You don't need to hear of something for it to be true." The deputy looked at me. "Sir, do you have identification and proof of ownership?" Without another word, I handed him my driver's license, registration, insurance card, and the original title I'd kept in a waterproof folder ever since the restoration was complete. He examined everything carefully. Karen watched him with crossed arms, completely unbothered. That should have been my first clue that whatever game she was playing had started long before that afternoon. "My name is Ethan Carter. I'm 48 years old, and I own Carter Classic Restorations, a small business in Franklin, Tennessee, where I restore vintage American and British automobiles. My shop isn't flashy. It's a renovated warehouse with faded brick walls, old steel beams, and decades of oil stains that refuse to disappear no matter how much you scrub. People often ask why I spend thousands of hours rebuilding machines most people would send to a scrapyard. The answer is simple. Old cars tell stories. Every dent, every scratch, every worn steering wheel carries someone's memories. Restoring them isn't just mechanical work. It's preserving history. That's why the Rolls-Royce Silver Cloud meant more to me than any customer project I'd ever completed. It wasn't just another classic. It belonged to my grandfather. My grandfather, Walter Carter, had bought the Silver Cloud in 1962 after years of working as a mechanical engineer. It was the one extravagant purchase he'd ever allowed himself. Growing up, I used to sit in that enormous leather back seat while he drove us through Tennessee's winding country roads. He treated the car like a member of the family. When I was 12, he let me polish the chrome hood ornament for the first time. "Take care of beautiful things," he'd told me, smiling. "They'll outlive all of us." I never forgot those words. After he passed away, the Silver Cloud remained in my father's barn for decades. Time wasn't kind. The roof leaked. Moisture spread everywhere. The paint disappeared beneath rust. The engine seized. Mice nested inside the seats. By the time I inherited it, most people laughed when they saw it. You'll spend more restoring it than it'll ever be worth. Maybe financially, but emotionally, it was priceless. 5 years earlier, I'd bought my home in Willow Creek Estates. It sat on nearly an acre at the end of a quiet cul-de-sac, with a detached garage large enough for 2 project cars. The neighborhood looked like something from a magazine. Perfect lawns, freshly painted fences, flower beds that changed with every season. Families waved during evening walks. Kids rode bicycles without parents worrying every second. For the first 3 years, life there was peaceful. The HOA existed, but barely. Annual dues paid for landscaping at the entrance, holiday decorations, and maintaining the neighborhood pond. Board meetings lasted 20 minutes. Nobody argued. Nobody cared. Then Karen Whitmore became HOA president. Everything changed. Karen moved into the neighborhood after purchasing one of the largest homes overlooking the pond. Within months, she joined the HOA board. 6 months later, she became president. Almost overnight, the neighborhood transformed. New rules appeared every few weeks. Mailbox colors, approved flower species, garbage can placement, holiday decoration deadlines, fence stain shades, exterior light bulb brightness. Even the number of hours garage doors could remain open. It became impossible to keep track. At first, I ignored most of it. I kept my property clean, paid my dues on time, and minded my own business. That should have been enough. Apparently, it wasn't. The first strange incident happened about 8 months into the Rolls-Royce restoration. I came home from work and found a bright orange notice taped to my garage door. Courtesy warning. The document claimed my abandoned vehicle violated neighborhood appearance standards. I laughed. The car wasn't abandoned. It sat inside my garage with the door open while I worked on it. Its engine was completely disassembled on labeled shelves. Every single part was catalogued. There wasn't anything abandoned about it. I called the HOA office the next morning. The receptionist sounded confused. "I'm sorry," she said after checking the system. "I don't actually see a violation filed under your address." "So where did this notice come from?" She hesitated. "It doesn't have a case number." I looked back at the orange paper. She was right. No case number, no inspector's name, no filing date, just Karen's signature. I crumpled the paper and tossed it into the recycling bin, assuming she'd made a mistake or gotten overzealous. I had no idea that was merely the opening move in a much larger plan. A week later, I arrived home to find someone standing at the edge of my driveway, quietly taking photographs of my garage through the open door. The woman lowered her phone the instant she noticed me pulling into the driveway. She didn't run. She didn't even look embarrassed. Instead, she calmly tucked the phone into her purse and smiled as though she'd been caught admiring my flower beds instead of photographing the inside of my garage. I stepped out of my truck and walked toward her. "Can I help you?" "Oh," she said pleasantly. "I'm just conducting a neighborhood inspection." "Inspection for who?" "The HOA. I've never seen you before." "You don't need to." That answer immediately put me on edge. "I'm going to ask again," I said. "Why are you taking pictures inside my garage?" She tilted her head. "Anything visible from the street isn't considered private. My garage isn't on a tour." I wasn't asking permission. Before I could respond, She walked back to a silver SUV parked across the street, climbed inside, and drove away without another word. I stood there watching her disappear around the corner, an uneasy feeling settling in my stomach. Something about the encounter felt rehearsed, deliberate, as if she had expected me to confront her, and already knew exactly what to say. That evening I found another envelope in my mailbox. This one looked official. It bore the HOA letterhead and my address printed neatly on the front. Inside were 3 violation notices. Not 1, 3. The first claimed I was operating an unauthorized commercial repair facility from my home. The second accused me of storing hazardous materials in a residential neighborhood. The third demanded the immediate removal of an unregistered, inoperable luxury vehicle that allegedly reduced surrounding property values. I read every page twice, then a third time. Each allegation was either exaggerated or completely false. I wasn't running my restoration business from home. I had a licensed commercial shop across town. The paint, solvents, and chemicals stayed there, not in my garage. As for the Rolls-Royce, it had been fully registered just 2 weeks earlier after passing inspection. I couldn't believe someone had signed their name to documents containing so many obvious inaccuracies. At the bottom of every page appeared the same signature, Karen Whitmore, HOA President. The following Tuesday, I attended the monthly HOA board meeting for the first time since buying my house. The clubhouse conference room was packed. Word had apparently spread. Karen sat at the front behind a polished oak table, dressed in a navy blazer with a stack of folders arranged perfectly in front of her. She looked less like a volunteer board president and more like someone preparing to prosecute a criminal case. When my turn came, I stood. I'd like to discuss the violation notices sent to my address. Karen adjusted her glasses without looking up. They've already been reviewed. Reviewed by whom? The Architectural Compliance Committee. I'd like to know who serves on that committee. They prefer privacy. A few people in the audience exchanged puzzled looks. I continued. The notices claim my vehicle is abandoned. It was. It wasn't. It appeared abandoned. It was inside my garage while I restored it. Karen folded her hands. The board determines community standards. The board doesn't determine reality. The room went silent. For the first time, Karen looked directly into my eyes. Her expression hardened. "Mr. Carter," she said evenly, "your attitude is becoming a problem." My attitude? Your unwillingness to cooperate. I've cooperated every time I've been asked. You've questioned board authority. I questioned false accusations. Same thing. Several homeowners shifted uncomfortably in their seats. One elderly woman quietly whispered, "That's not the same thing." Karen ignored her. She slid another folder across the table. The board has voted unanimously to impose daily fines until the violations are corrected. I picked up the document. $500 per day. I actually laughed. You can't be serious. Oh, we're very serious. The fines arrived every morning after that. $500, then another. And another. Within 3 weeks, the HOA claimed I owed more than $10,000. Certified letters followed, collection notices, threats of legal action, warnings that liens could be placed against my property. Every document grew more aggressive than the last. I responded with copies of my vehicle registration, business license, inspection records, and photographs documenting the restoration process. No one acknowledged receiving them. It was as though my evidence vanished into a black hole. Then things became personal. One Saturday morning, I walked outside and found bright yellow stickers plastered across the Rolls-Royce's windshield. Non-compliant property, subject to enforcement. The adhesive damaged the freshly installed glass when I peeled them off. That wasn't an accident. Whoever applied them knew exactly what they were doing. I checked my security cameras. The footage showed Karen entering my driveway just after 2 a.m., accompanied by the same woman who had photographed my garage weeks earlier. Neither carried any official identification, neither knocked on my door. They simply walked onto my property, placed the stickers on my car, took photographs, and left. I copied the footage onto 2 flash drives. One stayed in my safe. The other went into my briefcase. Something told me I'd need it. I just didn't realize how soon. 3 days later, I came home to find 2 county sheriff's deputies waiting in my driveway. Karen stood beside them with her arms crossed, wearing the satisfied smile I'd begun to recognize. One deputy stepped forward. "Mr. Carter?" "Yes?" "We've received allegations that you're refusing lawful HOA enforcement and that this vehicle may be subject to a disputed ownership claim." I looked from the deputies to Karen, then back again. That was the moment I understood this fight wasn't about neighborhood rules anymore. Someone was trying to rewrite ownership itself. The younger deputy shifted uncomfortably as he looked between me and Karen. "Sir," he said, "we're not here to seize your vehicle today. We were asked to verify the ownership dispute before this goes any further." I nodded slowly. "I appreciate that." Karen stepped forward before I could say another word. "Deputies, Mr. Carter has been misleading everyone. That Rolls-Royce was abandoned for years, and under the HOA's abandoned property policy, it became community property." I couldn't help laughing. Not because it was funny, because it was unbelievable. "Community property?" I asked. "You think an HOA can take ownership of a privately titled automobile because it sat in a garage during restoration?" She didn't flinch. "Our attorney disagrees." The older deputy looked at her. "Ma'am, that's not generally how vehicle ownership works." Her smile faded just enough for me to notice. It was the first crack in the confidence she'd displayed for months. The deputies documented everyone's statements, photographed the car, and copied my registration information before leaving. As they drove away, Karen looked at me with cold, calculating eyes. "This isn't over." "No," I replied. "I don't think it is." That evening, I called the one person I'd trusted with every major legal decision in my adult life. Daniel Mercer. Daniel and I had met nearly 20 years earlier when I restored a 1967 Mustang for his father. What started as a business relationship eventually became a friendship. He was now one of the most respected real estate attorneys in Williamson County, known for taking complicated property disputes that other lawyers avoided. When I finished explaining everything, there was a long silence on the phone. Finally, he asked one question. "Have you saved every single document they've ever sent you?" "I've got every letter, every email, every fine notice, every photo." "Good. What are you thinking?" "I think someone is counting on the fact that homeowners rarely challenge an HOA. But before I say anything else, I want to see everything." The next morning, Daniel arrived at my house carrying 2 leather briefcases and a portable scanner. He spent nearly 3 hours reviewing documents across my dining room table. Violation notices, certified letters, HOA meeting minutes, security camera footage, copies of my title, insurance records, receipts from every part I'd purchased for the Rolls-Royce. He barely spoke. Every so often he'd underline something or place a colored tab on a page. Around noon, he leaned back in his chair. "They've made mistakes." "What kind?" "The dangerous kind." He slid one of the violation notices toward me. "Look at the signature." I frowned. Karen signed it. "Now compare it with this." He opened another folder containing HOA bylaws that I'd received when purchasing my home. According to the governing documents, any fine over $100 required approval from at least 3 board members during an open meeting. Every one of my fines was signed only by Karen. No board approval, no recorded vote, no meeting reference, nothing. "So she issued them herself?" Daniel nodded. "If these records are accurate, yes. But that wasn't the part that bothered him most. He pointed to another page. "The abandoned property policy she's quoting. What about it?" "It doesn't exist." I blinked. "What?" "I've read your HOA's governing documents twice." He flipped through several hundred pages before laying the binder open in front of me. "There is no abandoned vehicle transfer clause, no community ownership clause, no authority to seize personal property, nothing even remotely close." I stared at the pages. "So where did she get it?" "That's exactly the question." Daniel filed public records requests with the county that same afternoon. He wanted everything. Every amendment to the HOA bylaws, every recorded easement, every board resolution, every deed connected to Willow Creek Estates, every document referencing the Whitmore Estate Trust. "If she's claiming ownership through a trust," he explained, "the county should have a paper trail." 3 days later, the records began arriving. Boxes, digital files, property maps dating back nearly 30 years. Most of it confirmed what we already knew. Karen's family had purchased their home only 4 years earlier. They had no historical ownership interest in the subdivision, no development rights, no adjacent parcels, nothing unusual. Then Daniel opened one PDF and suddenly stopped talking. He zoomed in on a recorded plat map. "That's odd." "What is?" He rotated the screen toward me. One corner of the subdivision was highlighted in yellow, my property. Running along the edge of my driveway was a narrow strip of land labeled as a private access easement, reserved decades earlier for the original developer to reach an underground utility corridor. The easement had never been transferred to the HOA. In fact, County records showed it had automatically expired almost 15 years before I bought the property. So Karen's latest filings described that expired easement as active. I frowned. Maybe she made a mistake. Daniel didn't answer immediately. Instead, he opened another file, then another. Finally, he looked at me with an expression I'd never seen before. It wasn't excitement. It wasn't relief. It was concern. She didn't make a mistake. What do you mean? He slowly turned his laptop around. Side by side were two documents. One was the genuine county plat map. The other was the version Karen had attached to the HOA enforcement packet. At first glance, they looked identical, until I noticed one detail. Someone had digitally altered the map. The expired easement had been relabeled as HOA Common Property. Daniel spoke quietly. If this document was knowingly altered before being submitted as evidence, he paused. This isn't just an HOA dispute anymore. I stared at the two maps for what felt like an eternity. They looked almost identical. The same survey lines, the same lot numbers, the same county seal. If Daniel hadn't placed them side by side, I never would have noticed the difference. But once I saw it, I couldn't unsee it. On the authentic county plat, the narrow strip beside my driveway was clearly labeled Expired Utility Easement. On Karen's version, those words had vanished. In their place were four bold words: HOA Common Property. Someone hadn't just made a typo. Someone had rewritten a legal document. I looked up at Daniel. Can they really do that? He slowly closed the laptop. No. And if they did it knowingly? His expression hardened. That's potentially document fraud. The room fell silent. For months, I'd believed I was fighting an overbearing HOA president with an inflated ego. Now it looked like I was dealing with something much more dangerous. Someone willing to alter official records to justify taking property that wasn't theirs. Daniel wasted no time. The following morning, he drove to the Williamson County Register of Deeds office with printed copies of both maps. An hour later, he called me. "Ethan," he said, "I need you to come down here." There was something in his voice that made me leave immediately. When I arrived, a senior records supervisor was waiting with Daniel in a conference room. Stacks of survey books covered the table. The supervisor adjusted his glasses before speaking. "We compared the documents submitted by your homeowners association against the certified original, and it wasn't issued by this office." My stomach tightened. "What does that mean?" "It means our seal was copied." He slid both documents toward me. "The county never produced this version." Daniel folded his arms. "So someone created it." The supervisor nodded. "That's our conclusion." I felt sick. Not angry, not shocked, just sick. Karen hadn't been bluffing. She'd built her entire campaign against me on paperwork that wasn't real. Word spread faster than I expected. Within days, homeowners started knocking on my door. Not to accuse me, to apologize. The elderly man across the street, Mr. Henderson, stood on my porch holding a pie his wife had baked. "I owe you an apology," he admitted. "I thought this was just another HOA argument." I smiled weakly. "It stopped being that a while ago," he nodded. "We've started comparing our violation letters." "What do you mean?" "Karen's been sending different versions to different people." That caught Daniel's attention immediately. "Different how?" Mr. Henderson pulled several envelopes from a folder. Every homeowner had received citations referencing different sections of the HOA bylaws. The problem? Many of those sections didn't exist. Others had been rewritten. One homeowner's notice quoted a landscaping rule. Another cited an architectural guideline. A third referenced a parking policy. Each version conveniently supported whatever Karen wanted at that moment. Daniel looked at me. "This isn't random." "No. It's systematic." Karen realized the neighborhood was beginning to turn against her. That's when the intimidation escalated. Someone spray-painted "Rule Breaker" across my mailbox. Anonymous emails arrived late at night. "Drop the lawsuit. You'll lose everything. Move while you still can." My business received one-star online reviews from accounts with no purchase history. A local supplier called to ask whether I was really under criminal investigation. Someone had started rumors that I'd stolen the Rolls-Royce from an estate auction. Every day brought a new lie. Friends stopped by just to make sure I was okay. One evening, my employee, Tyler, found the locks on my restoration shop packed with construction adhesive. Another morning, every tire on my trailer had been slashed. The sheriff's office documented each incident, but there wasn't enough evidence to make an arrest. Whoever was behind it knew exactly how close to the legal line they could get without crossing it in a way that was easy to prove. Then Karen made the biggest mistake of all. She called an emergency HOA meeting. Attendance was mandatory. According to the notice she distributed, nearly every homeowner showed up. Daniel came with me. Karen stood confidently at the front of the room. "Ladies and gentlemen," she announced, "Mr. Carter has filed frivolous legal claims that threaten the financial stability of our association." A few people nodded. Most remained silent. She continued, "If we don't act together, every homeowner here could face increased dues." She wanted fear. Fear made people easier to control. Then she held up the altered plat map. "This document proves the HOA owns the disputed property." Before she could continue, Daniel stood. Actually, every head turned toward him. He calmly walked to the front of the room, carrying a certified county copy inside a clear evidence sleeve. "I obtained this directly from the Register of Deeds yesterday." He placed it beside Karen's version. Gasps echoed through the clubhouse. Even homeowners with no legal background could see the differences. Karen's face lost all color. For the first time since I'd met her, she looked afraid. 2 weeks later, we officially filed our lawsuit. It wasn't just about my Rolls-Royce anymore. It included wrongful fines, trespassing, defamation, abuse of HOA authority, and alleged use of altered property records. Discovery requests went out the next morning. Subpoenas followed. The court ordered the production of emails, internal HOA communications, meeting records, and every document related to the enforcement actions against me. Daniel looked across his desk after filing the last motion. "They've spent months trying to intimidate you." I nodded. He closed the case file with a firm snap. "Now they have to answer questions under oath." The courtroom date was finally set, and for the first time since this nightmare began, Karen Whitmore couldn't control what happened next. The morning of the hearing arrived with a gray Tennessee sky that threatened rain but never quite delivered it. I parked across the street from the Williamson County Courthouse and sat in my truck for a moment, staring at my hands on the steering wheel. They were steady. That surprised me. For months I'd imagined this day. I expected to feel nervous, maybe even scared. Instead, I felt something closer to exhaustion. I was tired of certified letters, tired of rumors, tired of looking over my shoulder every time I pulled into my own driveway. Daniel knocked gently on my driver's window. "You ready?" I took a deep breath. I've been ready for months. Courtroom 4B wasn't large, but every seat in the gallery was filled. Homeowners from Willow Creek Estates occupied nearly 2 full rows. Several local reporters quietly unpacked notebooks and cameras in the back. The case had attracted attention after allegations surfaced that official property records may have been altered during an HOA dispute. Karen entered a few minutes later with 2 attorneys. She looked polished as ever in a cream-colored suit. But something had changed. The confidence I'd seen at every board meeting was gone. She kept whispering to her lawyers, flipping through papers with increasing urgency. When our eyes met across the room, she looked away first. The bailiff called the courtroom to order. Everyone stood as Judge Rebecca Lawson entered. She settled into her chair, reviewed the case file for a few moments, then looked over her reading glasses. "Counsel," she said, "I've reviewed the preliminary motions. This matter appears to involve considerably more than a disagreement over homeowners association rules." Daniel stood. "Yes, Your Honor. I believe the evidence will demonstrate a sustained pattern of unauthorized enforcement, false representations, trespass, and the use of altered documents." Karen's lead attorney immediately objected. "Your Honor, opposing counsel is making inflammatory allegations before evidence has been presented." Judge Lawson nodded calmly. "Then let's hear the evidence." Daniel called me as the first witness. After taking the oath, I sat in the witness chair and looked toward the judge. "Mr. Carter," Daniel began, "how long have you owned the Rolls-Royce Silver Cloud at issue in this case?" "It has been in my family's ownership since 1962. "Did you inherit it legally?" "Yes." "Did you possess a valid title throughout the restoration?" "I did." He handed me the original title. "Is this the document?" "It is." The clerk marked it as evidence. Daniel continued. "Did the HOA ever own this vehicle?" "No." "Did you ever abandon it?" "No." "Where was it stored?" "In my detached garage." "For how long?" "Nearly 3 years while I restored it." He nodded. No further questions. Karen's attorney stood for cross-examination. "Mr. Carter, isn't it true your garage door was frequently open?" "Yes." "So the vehicle was visible from the street?" "Sometimes." Would you agree it appeared inoperable?
It was under restoration.
So, inoperable. Temporarily, he smiled. Thank you. Daniel stood again. Your Honor, whether a vehicle is temporarily inoperable has absolutely no bearing on ownership. Judge Lawson nodded. Sustained. The next witness was the county records supervisor. He carried certified survey books into the courtroom. Daniel displayed 2 enlarged plat maps on electronic monitors. One genuine, one altered. Can you identify the first document? Yes, the supervisor said. This is the certified plat recorded by Williamson County. And the second? It is not. What differences do you observe? He pointed with a laser. The easement description has been digitally replaced. The county seal has been duplicated. The recording notation uses an incorrect font. The metadata indicates electronic modification after the original filing. The courtroom became so quiet I could hear reporters typing. Daniel asked the final question. Would your office ever issue this altered document? No. To a reasonable degree of professional certainty? No. Karen's attorney rose immediately. Objection. Speculation. Judge Lawson looked directly at the witness. He's testifying about records maintained by his office. She turned toward Karen's counsel. Overruled. Daniel's next witness was Mr. Henderson. He testified about watching me restore the Silver Cloud every weekend for nearly 3 years. Another neighbor described seeing Karen enter my driveway late at night. Then came the security footage. The courtroom monitors showed Karen placing bright yellow enforcement stickers across my windshield at 2:07 a.m. She had no board members with her, no county officials, no warrant, no permission. Karen walked to the witness stand with the same measured stride she'd used at every HOA meeting. Her posture was straight, her chin was high. From a distance, she still looked like someone completely in control, but I noticed something different. She wasn't carrying the thick binder she always kept tucked under her arm. For the first time since this nightmare began, she looked exposed. After taking the oath, she adjusted the microphone and folded her hands together. Her attorney began with simple questions. Mrs. Whitmore, how long have you served as president of the Willow Creek Estates HOA? Almost 3 years. And during that time, have you acted in what you believed were the best interests of the community? Absolutely. Were your actions toward Mr. Carter motivated by personal animosity? No. She answered each question smoothly, confidently, almost mechanically. If I hadn't lived through everything she had done, I might have believed her. Then Daniel stood. He approached the witness stand carrying nothing but a legal pad and one thin folder. No dramatic stack of exhibits, no oversized display boards, just one folder. That alone made me nervous. Whenever Daniel looked that calm, it usually meant someone else was about to have a very bad day. Good morning, Mrs. Whitmore. She forced a smile. Good morning. You testified that every action you took complied with HOA governing documents. That's correct. And every enforcement notice sent to Mr. Carter was properly authorized. Yes. Daniel nodded. Let's verify that. He handed her a certified copy of the HOA bylaws. Could you please turn to Article 7, Section 4? She flipped through the pages. I have it. Would you read the first paragraph aloud? Her voice slowed. Any monetary penalty exceeding $100 shall require approval by a majority vote of the board during a properly noticed meeting. She stopped. Daniel remained silent. The courtroom waited. Finally, he asked, how many board members approved the $500 daily fines issued against Mr. Carter? Karen hesitated. I approved them. I didn't ask who signed them. Another pause. How many board members voted? Her attorney objected. Asked and answered. Judge Lawson looked over the bench. The witness may answer. Karen swallowed. None. A quiet murmur spread through the gallery. Daniel walked back to counsel table and retrieved another document. This is the certified attendance record for every HOA board meeting during the relevant period. He placed it in front of Karen. Can you identify a meeting where those fines were approved? She searched the pages. 1 minute passed. Then another. Finally, she whispered, no. So the fines were never legally authorized. I believed I had emergency authority. Daniel immediately responded. Could you point the court to the bylaw granting that authority? Silence. There isn't one, is there? No. The next exhibit was the altered plat map. Daniel laid the authentic county survey beside it. Did you submit this document in support of enforcement against Mr. Carter? Yes. Where did you obtain it? Our records. Who created it? I don't know. Daniel picked up a certified statement from the county records office. The county has testified under oath that this version never existed in their files. He leaned slightly closer. So I'll ask again. Who created it? Karen looked toward her attorneys. Neither said a word. Judge Lawson spoke calmly. The witness is required to answer. Karen's shoulders dropped. It came from my husband. The courtroom erupted with whispers. The judge struck her gavel. Order, Daniel continued. Did you verify its accuracy before relying upon it? No. Did you tell homeowners it was an official county document? Yes. Even though you never confirmed that? Yes. Then came the email. Daniel projected it onto the courtroom screen. Every juror substitute, every homeowner, every reporter could read it. Nobody checks county maps anyway. Did you write this email? Karen closed her eyes. Yes. What did you mean by it? She couldn't finish. Daniel waited. Finally, she answered. I thought, if people believed the documents, they'd comply. You mean you wanted homeowners to accept your interpretation without verifying the records? Yes. The defense rested shortly afterward. Judge Lawson recessed for just over an hour before returning with her written findings. The courtroom became perfectly still. She looked directly at both parties before speaking. This court finds overwhelming evidence that the plaintiff, Ethan Carter, is the lawful owner of the Rolls-Royce Silver Cloud, and that the defendants possessed no legal authority to claim, seize, or interfere with that vehicle. Relief washed over me, but she wasn't finished. The court further finds that multiple monetary penalties were issued without authority under the governing HOA documents. She turned another page. The evidence also establishes repeated acts of trespass onto the plaintiff's property. Then her tone grew noticeably firmer. Most concerning is the submission and use of an altered property document represented as authentic. The room was so quiet I could hear someone take a sharp breath behind me. Judge Lawson looked toward Karen. This matter is referred to the Williamson County District Attorney for review of potential civil and criminal violations arising from the altered records presented during this dispute. Karen's face turned completely pale. The judge continued issuing orders. Every HOA fine against me was declared void. The lien threats were permanently barred. The HOA was ordered to reimburse my attorney's fees, restoration-related damages, towing expenses, and compensation for trespass and defamation. The total judgment exceeded $487,000. Then came the final blow. Effective immediately, Judge Lawson said. Mrs. Whitmore is permanently enjoined from exercising any authority on behalf of the Willow Creek Estates Homeowners Association unless lawfully re-elected following all corrective actions required by this court. Karen didn't say a word. She simply stared at the table in front of her. Outside the courthouse, reporters surrounded Daniel and me. Before any microphones reached us, I looked across the parking lot. The restored Silver Cloud sat gleaming beneath the afternoon sun, exactly where I'd parked it that morning. After everything that had happened, it was finally, unquestionably, still mine. 3 months after the trial, life in Willow Creek Estates looked completely different. The HOA board held a special election, and nearly every homeowner showed up. Several longtime residents volunteered to serve, promising transparency instead of intimidation. The endless stream of questionable violation letters disappeared almost overnight, and board meetings became what they should have been all along: short conversations about maintaining the neighborhood, not controlling it. As for me, I finally had the peace I'd been missing. On quiet Sunday mornings, I'd roll the restored 1958 Rolls-Royce Silver Cloud out of the garage, polish the chrome grille one more time, and take it for a drive along the same Tennessee back roads my grandfather loved. Every time I rested my hands on that large ivory steering wheel, I remembered something he told me when I was a boy. Take care of beautiful things. They'll outlive all of us. He was right. The Silver Cloud wasn't just a classic car anymore. It had become a reminder that the truth can survive even the most determined attempts to bury it. If this experience taught me anything, it's that you should never assume someone in a position of authority is automatically right. Keep your records, know your rights, ask questions, and don't let intimidation convince you to surrender what legally belongs to you. Thank you so much for watching and spending your time with me today. If you've ever had an HOA dispute, a difficult neighbor, or a property rights battle of your own, I'd genuinely love to hear about it. What's the craziest thing an HOA or neighbor has ever tried to do to you? If you enjoyed this story, please like, subscribe, and turn on notifications so you don't miss future stories of justice, perseverance, and unforgettable neighborhood conflicts. Until next time, take care of what matters, and never stop standing up for what's right. The end.